State's ready.
All right. Court will come to order. Court calls case number 604702. The charge is DWI. The date alleged is December 28, 2018. The defendant is Omar Tapia. The defense attorney representing Mr. Tapia is Alfonso Cabañas. Mr. Cabañas, do you expect your client to testify?
No, Your Honor, he will not testify.
All right. Now, for the record, Mr. Cabañas, can you certify that Omar Tapia is the same individual? Well, I'll do this. Mr. Tapia, are you the same Omar Tapia that is on the screen as Omar Tapia Badio?
That's correct, Judge.
And are you the same Omar Tapia, also known as Omar Tapia Badio, that was charged with the offense of DWI said to have occurred on December 28th, 2018?
That is correct, Judge.
All right. Mr. Cabañas, are you entering a plea on his behalf of not guilty?
Yes, Your Honor, a plea of not guilty.
All right. The defendant has been arraigned. We are ready to proceed. This is a motion to suppress, I understand.
It is, Your Honor.
And
Yes,
is
sir.
this was the alleged arrest without warrant?
It was, sir.
Yes, Your Honor.
All right. Then that being agreed to and established for the record, it is now the state's burden. Mr. Edelman, you may proceed.
State calls Officer Tustison to testify.
Say the officer is witness officer who?
Trevor Tustison.
Trevor. Can you spell the last name?
Tusti.
T like Tom?
Yes, sir.
Tusti.
Son.
Tustison. All right. Is the officer present? Yes, I see him. You are at this time muted, Mr. Tustison.
Yes, sir.
Thank you. Would you please raise your right hand? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, sir.
Thank you. Defense, and state, for the record, can we stipulate that that Officer Trevor Tustison is a employee of San Antonio Police Department, that he is a peace officer licensed in the state of Texas as such, and has been employed with San Antonio Police Department as a peace officer?
Yes, Your
Yes,
Honor, the defense will stipulate to that.
Very good. Then that'll save us a little time. We don't have to be dancing with that part of it. Officer Tustison, give me real quick, how long have you worked with SAPD?
Yes, sir. 4 years.
All right. So roughly you had 2 years experience when you made this arrest?
Yes, sir.
Okay. Do you have any special training in DWI arrest?
Yes, sir. I've been certified in standard field sobriety test.
I'm sorry. You are certified in the
Standard field sobriety test, sir.
and when's the last time you were so certified? Or hold on a second, please. This is John Longoria. Okay. Okay, I'm in the court right now.
Your Honor, I muted you.
All right, Mr. Edelman, you may proceed from there.
Officer Testison, were you on patrol on December 28th, 2018?
Yes, sir.
Were you working with a partner or were you working alone?
I was working alone, sir.
And what were your duties or responsibilities while you were on patrol on that date?
I was part of the DWI unit where I was tasked for looking for drunk drivers.
And could you briefly explain the responsibility? I'm going to pause, Your Honor, because it seems that Mr. Cabañas is experiencing some sort of technical difficulty.
You mean we're having difficulty with computers?
No, no difficulty, Judge. I just didn't want to confuse Officer Tustison or the court with too many Brady Bunch boxes, so I just turned my video off.
Well, I'll leave it on, please.
Yes, Your Honor.
Proceed, Mr. Edelman.
Thank you. While you were on patrol, were you patrolling in a vehicle?
Yes, sir, in a marked patrol unit.
Was that vehicle equipped with any sort of recording equipment?
Yes, sir, with what's called, it's our dash cam, we call it Coban.
And was that recording unit operating properly on December 28th of 2018?
Yes, sir.
Did it in fact make a recording of your encounter with the defendant?
Yes, sir.
Okay. Now, Your Honor, there's a bit of a technical difficulty because I have received an error message that the file I have uploaded to SharePoint cannot be played through that program. So I would like permission to share my screen with the courts for the purpose of having Officer Tustison identify for the court the recording that we would like to play.
Defense?
No objection, Judge. We're fine with that.
There's no action, then the
Your Honor, you're muted again.
quit doing that to me, Patty, please. All right, Mr. Edelman, proceed, please.
Thank you, sir. Officer, do you see this recording?
Yes, sir.
Can you identify it?
Yes, I can.
How can you identify it?
Because of the title on the top left has the defendant's name as well as the identification of being the front Coban and my last name and badge number.
And did you add your badge number and the date on which you added those items?
Yes, I added that.
Have you reviewed this video?
Yes, sir.
And as far as you are aware, based on your review, does it contain any edits or modifications?
No.
No, you're not aware, or yes, you are aware?
Oh, I'm sorry. I'm not aware of any modifications to the video. I'm sorry about that, sir.
No problem. That's just the response was subject to ambiguity, but now it's very clear.
Yes, sir.
Your Honor, at this time, I'd like to virtually tender the file to Defense Counsel for inspection.
Defense?
No objection, Judge. It's the same video that we've had for quite some time.
There being no objection, I presume you're offering it into evidence, Mr. Edelman?
With the court's permission, yes, I am, sir.
And there's being no objection, it is admitted into evidence.
And do I have the court's permission to publish?
You do.
Thank you, sir.
Excuse me, is this State's Exhibit 1 and should I mark it?
Yes,
I suggest you do.
Okay, give me a moment to do that, please.
of course.
Okay, thank you.
Let me interrupt a moment, just for the record, so everyone is aware. This matter is on video conference, is being presented to the public on YouTube. And for the record, Mr. Cabañas, are you and your defendant in agreement to have this by video conference as opposed to in public courtroom?
Yes, Your Honor, we are in agreement that because of the pandemic to proceed by video conference.
Very good. All right, just we'll continue. Thank you. Mr. Edelman, proceed.
Thank you, Your Honor. Officer, would you briefly narrate for the court what it is that is being recorded?
Yes, sir. Right now I'm driving westbound on Northwest Loop 410, right around West Avenue, approximately. When I see a white pickup truck in the far right lane, driving in the same direction.
At approximately what speed?
It was going approximately the speed limit, which is 65 miles per hour in that section of the highway.
And how did you judge or ascertain its speed?
Both through pacing as well as my front radar, which is the radar system is a Stalker DSR 2X. It's on both the front and rear of my vehicle.
Before you began your patrol, did you check to make sure that your radar unit was operating properly?
Yes, at the start and end of my shift, I calibrate it by doing a test on it with my remote and then calibrating it with tuning forks that I have in my go bag.
Now, at this point, do you notice anything unusual about the operation of the vehicle?
So initially, when I saw the vehicle, I saw that it had drifted over the solid right line over onto the shoulder. This was prior to this, where we're at right now. And as it was traveling, continued westbound, it had a slight drift within the lanes. And that is what I had noticed up until at this point.
Thank you. Now, at this point, can you narrate for the court if you perceive any traffic offenses or violations?
Yeah, so as it was taking the exit towards I-10 northbound, its passenger side tires went partially over the solid white line into the shoulder.
And to what extent?
To where the passenger side tires had left its main lane of travel.
What I just played, was that the violation that you believe you perceived?
That was the one of the indicators that I saw that drew my attention to it as well. Yeah.
Now, at this point, do you see any other indicators?
At this point, it strikes the left line, the left dotted line. Again, making that wide left or right turn.
Do you see any violations at this point?
Yes, once again, it drifted onto the shoulder, even more so than it did prior, to where the entire passenger side tires were onto the shoulder.
Now, could you please narrate for the court what is happening?
Well, I'm still following the vehicle. It's continued to drift side to side, and it's taking the exit towards Medical Drive and Wurzbach.
Is there a speed limit sign shortly after that exit?
Yeah, right once you enter onto the access road, there is a speed limit sign for 45 miles an hour.
Thank you. Could you please point out to the court, if possible, where that speed limit sign is relative to where your patrol vehicle is located?
So it's going to be on the right side of that access road, close to where that street lamp is, approximately, where it's going to have that 45.
Where I am circling my cursor, if you can see it, is that approximately where the speed limit sign is?
Yes, sir.
Thank you. Now, are you using your radar units at this point?
Yes, sir.
And is your radar unit locked onto this particular vehicle?
Yes, sir.
And what speed does it detect?
As it passes the speed limit sign, it's going 60 miles an hour.
Is that in excess of the posted speed limit for that area?
Yes, sir.
Thank you. Now, would you please narrate for the court what is happening?
So it's made a series of right lane changes using its turn signal. It slowed down to 55 miles an hour, but was still exceeding that speed limit. And at this point, I turned on my emergency lights in order to initiate a traffic stop.
Now, will you eventually make contact with the operator of the vehicle?
Yes, sir.
And the operator of the vehicle on that evening, do you see that person virtually here in the courtroom today?
Let me open up the rest of the videos. Sorry.
Yes, of course.
Yes, sir.
And could you point that person out by any distinguishing features that you can perceive?
Yes, sir. Right now he has a beard and a blue polo shirt.
Thank you. Now, when you first approached the operator of the vehicle, did you perceive anything unusual or out of the ordinary?
Yes, he had a dry stain on the passenger side, in the driver's side door. He had what looked like a stain on his right pant leg. He had glossy and bloodshot eyes at the time. I couldn't smell anything, and I remember this is the end of December, which we're getting into cedar season, and my nose was pretty stopped up at this point.
Were those the only perceptions that you made at the time?
Yeah, that was my initial perception. As the interview progressed, I started noticing other little things. He spoke slowly and articulated his words a little bit more than what I would normally perceive a normal speech. But again, I had never met the individual.
Now, at what point do you ask, or it may be more appropriate to say that you order Mr. Tapia out of the vehicle?
So this was, I start asking him where he's coming from. And he tells me he's coming from a place called Diversions Gaming. I was unaware of at the time, called on San Pedro Avenue. He tells me he hasn't had anything to drink. He hesitated a little bit. I returned back to my vehicle, and that's when I kind of talked to the second officer that was there, who's Detective Henning. After talking with him, I go back to the car and I agree to, or not agree, I decide to continue with the evaluation for possible DWI.
Now, Your Honor, with permission, I would like to skip ahead in the recording to the point where Officer Tustison orders Mr. Tapia out of the vehicle.
Defense?
That's fine with me, Judge.
There being no objection, you may proceed, sir.
At this point, is Mr. Tapia under arrest?
No, sir.
And why not?
Because I have nothing to arrest him for.
Now, at what point did this other person arrive on the scene?
Detective Henning?
Yes.
You mean? I can't tell you specifically. This was after I made contact with the driver. This was after I had returned to my vehicle. I can't tell you specifically in what reference at what point he decided he showed up.
If you recall, did you request him or did he arrive of his own volition?
He arrived on his own, seeing as how on the DWI unit we drive solo. Oftentimes, if we see another one of ours stopped with a vehicle, we'll kind of stop on our own just to cover, just in case.
So it was simply a matter of happenstance that he arrived at that point?
Yes, sir.
Now, as far as you're aware, was there anything impeding Officer Henning's ability to perceive with the sense of smell?
No, sir.
And how do you know that?
It wasn't until afterwards, after the arrest was made, that he told me that he could smell an odor of intoxicants coming from the defendant.
But you yourself did not perceive that.
No, sir. As I said, we were getting into cedar season at that point, and I was pretty bad.
Did you have any reason to doubt or question the reliability or veracity of what Officer Henny told you?
No, sir.
Did you take that into account when making your eventual arrest decision?
As far as that odor, when he told me he had smelled it, I had already made that arrest decision. He had not told me that he could smell anything up
Thank
until
you.
that.
Thank you. Now, if you remember, can you narrate for the court what it is that you're telling Mr. Tapia?
As far as specifically what's happening in this point, no. I'm imagine I'm going through the same interview process I have. I'm asking about medical conditions, if he has diabetes or epilepsy, medical conditions, head trauma, or taking medication. He's denying these incidences or these issues. And at that point, I asked him if I could check his eyes to make sure he was okay to be driving, and he allowed me to do that.
Now, are you certified in the administration of the standard field sobriety tests?
Yes, sir.
Would you briefly explain the standard field sobriety test that you are about to administer to Mr. Tapia?
So this is what's called the HGN test, or the horizontal gaze nystagmus test. Essentially what I'm doing is I'm moving a stimulus from side to side or horizontally as I look for a visible nystagmus in their eyes.
And would you briefly explain the steps of determining whether a person is a good candidate for this particular evaluation?
Yeah, so before I actually begin with HGN, I qualify the candidate. For qualifying the candidate, I look for resting nystagmus, which is that I'm going to see that involuntary jerking when the eye is at rest. I'm looking for equal pupil size to determine if I see any medical conditions or anything that might prevent an accurate reading, as well as I'm looking for equal tracking to see that the eyes track the stimulus from side to side equally.
And did you perform each of the steps of the qualification process with Mr. Tapia?
Yes, sir. I performed those and determined that he was a qualified candidate.
Now, as you perform or administer the HGN evaluation, do you notice anything about Mr. Tapia's body?
As I'm well, during the actual test, no, I don't see any I notice any visible swaying or anything at that point.
Could you please narrate for the courts what portion of the evaluation you are conducting now?
At this point, I'm checking for again equal tracking, wherein I go straight into the first clue of HGN, which is lack of smooth pursuit.
And how do you determine whether someone lacks smooth pursuit?
So it's roughly the best example I can give for lack of smooth pursuit is how a windshield wiper goes across a dry windshield. Basically, that there is no smooth passing of those pupils across their eyes as they move from side to side. It's you see the jerking as it moves side to side.
Now, would you briefly narrate for the court what other parts of the evaluation procedures you have gone through and are now administering?
So at this point, what I'm administering is the second portion of the HGN, or the second set of clues that I'm looking for, which is distinct and sustained nystagmus at maximum deviation.
And at this point, are you still in the distinct and sustained evaluation portion of the evaluation?
No, right now I'm doing what's called onset of nystagmus prior to 45 degrees, where I'm checking for nystagmus prior to reaching 45 degrees on that horizontal or that lateral movement. At this point, I'm going into vertical gaze nystagmus.
Now, would you briefly explain to the court the standardized steps of the lack of smooth pursuit, the distinct and sustained, and the onset prior to 45 degrees?
Yes, sir. When I hold the stimulus approximately 12 to 15 inches from the individual's face, for lack of smooth pursuit, I move the stimulus first to my right or his left, and I move it at approximately 2 seconds to where it's reaching at that maximum lateral movement. And then I go back to his right eye or my left side, and I do that for 2 seconds, and I do that for 2 passes each. After this, I go to distinct and sustained nystagmus at maximum deviation, where I hold the stimulus at maximum deviation or as far as the retina will move to the side for approximately 4 seconds. I will do this for each eye twice. And then on onset of nystagmus prior to 45 degrees, I will take approximately 4 seconds to where I will reach, at what point I'll reach 45 degrees from the center line of the defendant's face to determine if I see that involuntary jerking prior to reaching that 45-degree angle. I'll do that starting again with his left eye or my right side, and I'll do that twice for each eye.
Now, I heard you say approximately several times.
Yes,
Is
sir.
that the recommendation of the NHTSA manual?
Yes, sir. It says at least 4 seconds, but as long as it doesn't reach an extended period beyond that, particularly with distinct and sustained nystagmus at maximum deviation, then it's a valid reading.
So when the NHTSA manual recommends that you maintain the stimulus approximately 12 to 15 inches from the subject's eyes or face, does it in fact mean that is an absolute requirement that the stimulus be between 12 and 15 inches from the subject's eyes or face?
So what they've said is that the 12 to 15 inches is the standard. However, if it's held closer or further away, they show no there's no change in the results that they get from the readings from the nystagmus.
And similarly, for the lack of smooth pursuit, is it a requirement that each pass be 2 seconds?
Again, it's a standard and approximation. So yeah.
So if, for instance, the stimulus was more or less than 12 to 15 inches, that would not in and of itself invalidate the results?
No, sir.
Or if a stimulus was passed in more than 2 seconds for the lack of smooth pursuit, that in itself would not invalidate the results?
No, sir.
At least according to your training and experience?
Yes, sir.
Now, at this point, what if anything, have you observed as a result of your administration of this evaluation?
So after conducting this test, I found that he had all 6 clues of horizontal gaze nystagmus, as well as I did see vertical gaze nystagmus.
And what does that indicate to you at that point?
That he is above the legal limit of 0.08, as well as with vertical gaze that he has ingested more alcohol that he might be accustomed to.
Now, is alcohol the only substance that causes horizontal or vertical gaze nystagmus?
No, sir.
What other substances could cause that physiological response?
What you're looking for are certain drugs or medication, CNS, the central nervous system depressants. So medication usually that people take for anxiety or depression can cause nystagmus or can exacerbate that nystagmus, as well as inhalants can create that nystagmus as well.
So at this point, you suspect that Mr. Tapia has ingested alcohol, but do you actually know?
But I actually what? I'm sorry?
Do you actually know it?
That I actually know? Is that what you're saying?
Yes.
Oh, yes. That at this point I've determined he's at least ingested some central nervous system depressant. Alcohol is a CNS depressant, as well as those other medications.
Now, are you combining your observations of the evaluation with other observations that you've made of Mr. Tapia at this point?
Yes, sir. At this point, again, I'm looking, I have in mind his driving factors, as well as my interview, as well as what I've observed from him up until now. Like I said, the stain on the car, the stain on his pants, and now the HGN.
Thank you. Now, after the administration of the HGN and VGN evaluations, are there any other standard field sobriety tests that you will administer to Mr. Tapia?
Yes, sir. At this point, I'm going to be going into the walk and turn portion of the which is another standard field sobriety test, and then later the one leg stand, which are another standard field sobriety test.
And would you briefly explain the walk and turn to the court?
So the walk and turn is a divided attention test, wherein the defendant is required to divide their attention and do several tasks to determine if they're able. It's a sobriety test enacted by NHTSA. So.
And could you please explain to the court what a divided attention test is?
Like I said, it's designed to divide their attention, to have their mind set at one thing and do another. This walk and turn is a divided attention test, as well as driving. Driving is a divided attention test, wherein we're required to steer the vehicle while pushing on the brake or gas, while doing the walk and turn, during doing the turn signal. All these things are the driving is in and of itself a divided attention task.
Now, could you briefly recite to the court the instructions for the walk and turn evaluation?
Yes, sir. I have them imagine a straight line about the width of their foot that goes towards the front of my license plate. At that point, I ask them to step with their right foot in front of their left foot, heel toe, and to maintain that position while I give them instruction. After they understand that, I proceed to demonstrate the test. I tell them to take 9 heel to toe steps along the imaginary line in front of them. And then when they reach that 9th step, they're going to keep that lead foot planted. They're going to take a series of small steps to turn around, and then they'll take 9 heel to toe steps back. After demonstration of that test, I'll tell them to look down at their feet while they do it, count their steps out loud, keep their hands and arms down by their side, and once they start, don't stop until they finish the test.
Now, are there any clues that you look for or pay attention to during the instruction stage?
Yeah, so in the walk and turn, there are two phases. It's called the instruction stage or the instruction phase. And then the second portion is the walking stage or walking phase. So during that instruction portion, I'm looking to see if they're able to stay in that position that I asked them to be in that original position, with the right foot in front of the left foot. And then I see if they're going to start before I tell them to begin. Those are the first two clues I'm looking for.
Thank you. Now, officer, so far, do you perceive any clues for the walk and turn?
Yes, sir. So he has two clues. He doesn't touch heel to toe on several steps, leaving more than a ½ inch gap between the toe of his one foot and the heel of the other. As well as when he turns, he doesn't maintain that planted foot and take a series of small steps. As you see, he pivots on both feet. I also noticed several other things that aren't inherently clues according to the standard field sobriety test, but that are just things of note. For example, I see him sway a little bit from side to side as he walks. Even though his hands don't extend more than 6 inches from his body, you can see his arms are kind of loose from his side, and he didn't look at his feet when I had instructed him previously.
Thank you. From this additional phase, did you perceive any other clues?
Again, there were several steps. He didn't touch heel toe in the totality of that walk and turn, but at this point, no other additional clues.
So how many clues are there for the walk and turn total?
In total, there are 8 clues. I observed 2.
And what, if anything, does that tell you about the person undergoing the evaluation?
So with 2 clues is the minimum requirement to determine intoxication according to the NHTSA standards. So again, it's telling me that there's some degree of impairment from him.
But it doesn't specifically tell you that that impairment is caused by alcohol?
Again, that's combining with several of the other factors or the totality of the circumstances that I use that to make that determination.
Thank you. Now, what is the next standard field sobriety test?
It's called the one-leg stand.
And what are the requirements for the administration of the one-leg stand?
The requirements are that they stand on one foot for approximately 30 seconds while they count in a manner that I tell them to count, 1001, 1002, 1003, with their hands down by their side, their legs straight, and while looking at their feet. They're going to be performing this test.
Do you need to qualify the person for this test in any way?
Again, this is usually done through the medical, asking if they have any medical conditions or anything of note that would prevent them from doing it.
Now I'm going to back up for a moment. When Mr. Tapia taps his right leg. Do you remember what it was that he was telling you at that time?
I don't, sir.
Now, did you ask Mr. Tapia if he had any medical problems that would interfere with his ability to perform in the evaluation?
No, nothing that I could determine.
Anything that he told you based off of your prompt?
No. Now again, I can't recall why he's pointing out his right leg. I know in past experience, when I'm told that they have an injury to a certain leg or some sort of pain, I ask them to that again, they can lift up any leg, but that I suggest they lift up that leg so that they're not putting any pressure on that leg. Again, I can't recall with regards to Mr. Tapia, but that's usually the process I go through.
Now, similar to the walk and turn, is there an instruction phase for the one leg stand?
Yes, sir. I ask them to stand with their feet together, with their hands down by their side, and to not begin the test until told to.
And then what are the instructions specifically for the one leg stand?
Again, when I tell them not to begin, I instruct them that they need to lift up a leg, any leg of their choice, approximately 6 inches off the ground. They're going to keep their legs straight. They're going to maintain their foot parallel to the ground with their hands down by their side. They're going to look down at their foot and count out loud 1001, 1002, 1003, 1004, and so on and so forth until I tell them to stop.
Now, what clues are you looking for during either the instruction phase or the performance phase of the evaluation?
So there's going to be 4 specific clues with regards to the one leg stand that I'm looking for. That they keep their foot elevated, that they keep their hands down by their side, that they don't sway, as well as that they don't hop, or that they keep that planted leg in that firm position.
Similar to the way that you're demonstrating to Mr. Tapia now.
Yes, sir.
Is there a reason why you have Mr. Tapia oriented in the manner that he is relative to your vehicle?
Usually I do that so to get multiple angles from the both the Coban as well as body cam.
Now, as a result of the evaluation, did you perceive any clues for this standard field sobriety test?
No standard clues. He didn't look at his foot while performing the test, but again, I out of the 4 possible clues, I didn't see any.
Now, up to this point, had you made a decision whether or not you believe you had probable cause to arrest? And if so, arrest for what?
Yes, at this point, based off of his driving, the vehicle factors, where he was, my interview with him, as well as the standard field sobriety test, I had determined that he had lost his mental and physical faculties and was driving a motor vehicle while intoxicated.
So at this point, you had already made the arrest decision?
At this point, I'm coming to that conclusion. Yes, sir.
Thank you. Now, after placing Mr. Tapia under arrest, did you read him any warnings?
Yes, sir. I read him the Miranda warning or his rights.
Did you read him or recite for him any rights related to the provision of a breath or blood sample?
Yes, sir. I put him in the back seat. I transported him to 401 South Frio, and then I read to him the DIC 24 or the statutory warning.
Did you ask Mr. Tapia for a specimen of breath or blood?
Yes, I requested a breath sample and then a blood specimen. He refused.
And what did you do after that?
I created a warrant, which was signed by the on-duty magistrate. And then I proceeded to get a blood specimen from him.
Do you happen to remember who the on-duty magistrate at that time was?
I'm sorry.
I take it that means you do not remember.
Oh, yeah. I'm sorry, sir. Yeah, I don't remember.
But the warrant was signed by an on-duty magistrate.
Yes, sir.
Was the warrant dated?
Yes, sir.
Do you remember the date for the warrant?
The date would be the same time as well, the return would be the same time as the time the blood specimen was taking. It was either the day of the stop, which was the 28th, or the 29th. Again, the blood specimen was taken at 12:23. So the signing of it would either be shortly after midnight or shortly before.
And how long after the issuance of the warrant was the warrant executed?
Again, I can't tell you. I don't have access to the warrant right now with me as far as when it was signed by the on-duty magistrate and when it was taken into effect. But as I said, the blood specimen was taken at 12:23 a.m.
Was the warrant executed within 3 days of its issuance?
Yes, sir.
Thank you. Your Honor, at this time, we'll pass the witness.
Excuse
Cabañas.
me, Judge, can we take a quick break?
Yes, ma'am. Order
5
being
minutes,
recessed.
okay?
Pardon me?
Maybe 5 minutes?
That'll be fine.
Okay, thank you.
I'll give you 7.
Thank you very much. I'll see you in a few.
Alrighty.
Your Honor, may I be excused for a few minutes?
Yes, you may. You got a total of 6.5.
Thank you, sir.
You're welcome. Ms. Rivera,
Yes, sir.
you all ready to go?
Yes, sir. Thank you very much.
We should say ready to return. All right, we'll get back to order. Mr. Cabañas, your witness.
Thank you, Judge. Officer Tusterson, can you hear me okay?
Yes, sir.
Okay, great. So Officer Tusterson, before I begin my questions about that day, I just want to clarify. So the 4 years you've been with SAPD, are they 4 years on March 11th, 2021, or 4 years on December 28th, 2018?
I'm sorry. What's the question?
Yes, you testified earlier that you have 4 years with SAPD, right?
Yes, sir.
Okay. Now those 4 years, are you counting as of March 11th, 2021, or are you counting 4 years as of December 28th, 2018?
Oh, I'm sorry. 4 years as of today.
Okay. Okay. So in 2018, you had about maybe 2.5 years.
Yes, sir. I graduated from the academy in April of 2016.
Okay.
So
Okay. Perfect. Now, on that day, December 29th, 2018, Officer Tusterson, when you're following Mr. Tapia's vehicle, you mentioned that from the time you were following him on 410 and around West Avenue to the time he exited off of Medical and off a Medical Drive, you noticed that his tires either hit the shoulder, or I think at least on one occasion you testified one of the tires did go over the shoulder, correct?
yes, sir.
Okay. So is the reason for the stop that alleged traffic offense that he didn't maintain a single lane, Officer Tusterson?
That in combination with the speed on the access road.
Okay. Now, regarding the access road, you testified that, well, let me backtrack. You testified that he was driving the speed limit on the highway, 65, correct?
Approximately around that.
Okay. So we know he wasn't speeding on the highway, right?
Yeah, nothing stood out to me as far as his speed on the highway.
Okay. Now, when you talk about him exiting Medical Drive and getting on the frontage road, you testified that there's a speed limit sign as you exit to get on the frontage road, correct?
Yes, sir.
Okay. And according to your report, that speed limit is 45, right?
Yes, sir.
Okay. But in your report, you also mentioned that as he's exiting, he is slowing down his speed, correct?
He ends up slowing down to 55, sir.
Okay. Now, as he's driving on the highway, Officer Tusterson, based on your report, there aren't any accidents, right?
No, sir.
Okay. Mr. Tapia doesn't hit any barriers, right?
No, sir.
Okay. As he's driving, he is using his left and right turn signal, correct?
Correct, sir.
Okay. So when you finally turn on your red and blues, officer, to stop him, Mr. Tapia has no difficulty pulling over and stopping, correct?
Correct.
In fact, he pulls over at his safe spot, right?
Yes, sir.
Okay. You didn't have to chase him for an extended period of time, correct?
Correct.
Okay. Now, the approach, and I'm going to spend a little bit of time on these questions because I want to give the court, I want to show the court, what was skipped over during the state's question, okay? So as you're approaching him, at this time, your only concern is what you claim is a traffic offense, correct?
Yes, but at the same time, due to his driving, I also expected to conduct an investigation, albeit whether or not that investigation led to standard field sobriety tests or no. But I expected to ask him a few questions.
Okay. So as you approach the vehicle, you testified a little bit earlier during direct examination, officer, that you noticed there was a stain on the driver's side door, correct?
Yes, sir.
Okay. And you testified you believed that it was vomit, right?
It looked like it might have been.
Okay. But you didn't inquire any further, correct?
Correct.
Okay. And in fact, even though you you couldn't smell that day because of allergies, your partner, Officer Henning, didn't tell you that the odor of vomit or throw up was coming from Mr. Tapia, correct?
Correct.
Okay. All right. Now, before you even get to asking Mr. Tapia to get out the car, you you take your time asking some questions, correct?
Yes, sir.
Okay, because that is part of your investigation, right?
Yes, sir.
Okay. So when he's sitting in the vehicle, right, you notice that he stopped his car safely, correct?
Yes, sir.
Okay, he turned the car off, right?
I can't recall that, sir.
Okay.
I don't-
All right. Do you remember him, or did he, place it in place the gear in park?
I don't remember, sir. I remember the vehicle wasn't moving when I approached, or caused any of that.
Okay. All right. But when he stepped out of the vehicle, it didn't move, correct? Or it didn't
Correct.
just, all right. You saw Mr. Tapia roll down the window, right?
Yes, sir.
Okay. He provided you with, and I think you may have asked him for his driver's license and insurance, right?
I asked for driver's license. Rarely do I ask for insurance.
Okay. Did he provide you with his driver's license?
Yes, sir.
Okay. And then he told you where he was coming from, right?
Yes, sir.
A place called Diversions?
Diversions gaming. Yes, sir.
Okay. And he went ahead and further told you it was a place where they had almost like arcade or video games, right?
Yes, sir.
Okay. He mentioned to you that he did not have any alcoholic drinks, right?
Correct.
He also told you where he lived, right?
Yes, sir. If I remember correctly, it was pretty close by
Okay.
to where the stop was made.
Okay. I think he may have signaled and said, "Oh, I live right down the street," right?
Yes, sir.
Okay. He also told you how long he's owned the pickup truck he was driving, right?
Yes, I believe I asked him if he had any issues with the truck, and he said no.
Okay. He told you that he was from San Antonio, right?
I don't remember that portion, sir.
Okay. I think you asked him and he may have answered whether he went to college or high school, right?
Yes, sir. Usually that's my precursor to asking about the alphabet.
Okay. And that was the next question. And so I want to bring that up, officer, because again, the state didn't ask you about that particular test, but prior to this point, okay, based on your testimony, we know that the allegation of a traffic offense and what you claim to be dry vomit, that was your initial, I guess, suspicion that Mr. Tapia was intoxicated, correct?
They were possible indicators. Yes, sir.
Okay. So then you ask him to recite the alphabet, correct?
Yes, sir.
Okay. And I believe you tell him to recite it without singing the song, right?
Yes, sir. I asked him to say it from C as in cat to V as in Victor without singing the song.
Okay. And based on your report, It says that you didn't hear any problems in his recitation, right?
Right. He started at D as in Delta, but then ended at V as in Victor. But as far as the order of the alphabet or missing letters, no, I didn't notice anything.
Okay. And when he's reciting the alphabet, Officer Tustison, he's not slurring his speech, right?
Not that I can remember, sir.
Okay. Well, you didn't mark it in your report, did you?
No, I didn't, sir.
Okay. So it's safe to say he wasn't slurring his speech.
Correct.
Okay. And he also wasn't mumbling through the recitation of the alphabet, correct?
Correct.
Okay. Let me go back to my questions. Okay. Now, at this point, this is based on what you've seen, based on the recitation, you still have that hunch that he may be intoxicated, right?
Yes, sir.
Okay. So at this point, even though he told you that he wasn't drinking, right?
Correct.
Even though he recited the alphabet without any slurring or without any problems, right?
Yes, sir.
You still didn't let him go.
Correct.
Okay. So then at this point, now there's a point, Officer Tustison, and it wasn't in the video, but I'll ask the court to take judicial notice, but there's a point in the video where you go back to your car, and I believe Officer Henning is inside the vehicle, right?
He's standing outside of my vehicle looking in. So I'm sitting in my driver's side and I'm talking to him through the passenger window of my
Okay.
car.
Okay. And so when at that conversation, officer, if you can remember, at that conversation, I think you stated very clearly, hey, my nose is clogged up. I can't smell a thing, right?
Correct.
And then you kind of summarize to Officer Henning what you found so far, right?
Yes, sir.
Okay. And then Officer Henning tells you something along the lines, well, the test that I do or the test that I conduct to determine if they're intoxicated, and it gives you about 4 factors, right?
Thought it was 3, but yeah, one, yeah, around there.
Okay. So at this point, is it the fact that that Officer Henning gave you those 3 factors? That's what kind of guided you to go back and do more tests of mesothopia, correct?
Well, yeah. So at this point, even though I had about 2.5 years on the department, I only had about a year on the unit, and Officer Henning at that time, he's now Detective Henning, he had a lot more time than I did, and he kind of helped me when he told me when he determines whether or not to conduct standard field sobriety tests. He gave me those 3 factors on when he does.
Okay.
And yeah.
Okay. But if Officer Johnson, those 3 factors, those are factors that Detective Henning uses. They're not factors that are in the NHTSA manual, correct?
Correct.
Okay. All right. So as you ask him to step out of the truck, Officer Tustison, again, in your report, there's no evidence whatsoever that Mr. Tape had any difficulty exiting his truck, correct?
Correct.
Okay. He wasn't leaning on the truck, right?
No, sir.
He wasn't, I guess, being supported by the truck so he wouldn't fall over, correct?
Correct.
And those are issues that you are taught by the NHTSA manual to observe to determine whether or not your suspicion of intoxication is correct, right?
Correct.
Okay. Now, as let me get through here. As he's stepping down, he's following your instructions, correct?
Yes, sir.
And I think you mentioned in your report that, you know, he wasn't swaying or falling down as he was walking, right?
No, I didn't notice any unsteadiness at the time of the interview.
Okay. Now, we see that the first standardized field sobriety test, well, I'm sorry, as you're qualifying him, excuse me, after you qualify him, you do the HGN test, correct?
Yes, sir.
All right, give me a second. Now, on the HGN test, officer, if you remember from your NHTSA manual, they tell you that the person, in this case, Mr. Tapia, who has the test being administered to, there can't be any bright lights or any red and blues flashing in his face, correct?
Yes, sir.
Because those bright lights, what happens to the test? Is it invalidated?
Yeah, so when you have those strobe lights, yeah, those can affect the readings of the HDN.
Okay. And the NHTSA manual also tells you to face him away from any roads or from any traffic that may be, I guess the lights again may impair the HGN test, correct?
With regards to the passing lights, that can, if they're looking at those lights, that can just add to a distraction to prevent them from following the stimulus.
Okay. So during the first HGN test you performed, we saw in the video that to your left, right, which would be my client's right, we have your vehicle, your patrol vehicle and Detective Henning's vehicle with the lights and the strobe lights turned on, correct?
The rear ones are turned on, the front ones aren't.
Okay. And those lights are interfering or they're hitting Mr. Tapia's face, correct?
Again, the rear red and blue ones are not, because the front ones are cut off.
Okay. But the vehicle lights are hitting him in the face, correct?
Yes, sir.
Okay. And then on this first HGN you performed, behind you, Officer Tusterson, there's a frontage road with multiple cars passing by, right?
Yes, sir.
And these cars could have caused a distraction during the HGN test, correct?
They could have, which is why I pointed out that the reason why you have them facing away from traffic is to prevent them from looking at the traffic as opposed to the stimulus. When I performed the HGN test, he was following the stimulus.
Okay. Well, and we know that it interfered because if you recall, you performed a second HGN test, right?
Yes, sir.
And that second HGN test, you had Mr. Tapia face completely away from oncoming traffic, right?
Oh, yes, sir. That
Okay.
that wasn't. He wasn't positioned that as a result from interference. He was positioned like that because he had just done the one leg stand.
Okay. All right. So now let's go to the walk and turn test, Officer Tusterson, which is the second test you administered.
Yes.
All right. So on that one, you told the court that you observed only 2 out of the 8 clues, correct?
Yes, sir.
Okay. You mentioned that according to you, he did not touch heel to toe on several steps, right?
Yes, sir.
Okay. And did not look at his feet while he walked. Is that right?
Yes, sir. The looking at that feed is merely an observation, and that's not a clue for the walk and turn, though.
Okay. All right. So if you remember the 8 clues from the walk and turn, so we know that he kept his balance during the instruction, right?
He didn't step off the line, sir.
Okay.
No.
He started right when you told him to start, correct?
Correct.
Okay. He didn't stop while walking, right?
Correct.
Okay. Now, did you just add a 3rd clue and say that he stepped off the line?
Oh, no, I said he didn't step off the line.
Okay, so he didn't step off the line. Okay. And he also did not raise his arms for balance, right?
No, like I mentioned, he kept them loose, but he didn't extend them far away from his body.
Okay.
To clue.
Okay. And these 6 clues that you did not see, you observed them on, on the walking and the returning, correct?
Correct.
Okay. Or did you only observe those 2 clues on the first walk through, on the walk and turn?
So the clue of not stepping on in heel toe fashion, that was both on the to and fro or going and coming back. The second clue of turning incorrectly, that was on the turn. So
Okay. All right. Because you don't have those marked off on the return in your report, officer,
on
on the walk and turn.
Well, usually I mean, yeah, I didn't write it on the return because
Because it didn't happen.
well, no, not necessarily. No, not at all. It's just I put the check whether or not it happened or not. Whether it happens on the return or on the going makes no bearing on whether or not the clue was there.
Okay. So if it makes no bearing, then why is there a column dedicated just to the return part on the walk and turn? Are you saying that that's not part of the test?
Well, sir, I mean, if you notice, there's a return column on several clues. Return column on stops while walking.
That's right.
Return column on everything. But that
I understand, officer, and I'm not trying to confuse you. Is it that I'm looking at your report, and so on the return clues, there's no indication that he stopped while walking, right? And I'm looking at the
right,
return column, right?
right,
There's also no indication that he did not touch heel to toe, right?
right. I didn't put that in the
Okay. There's no indication that he stepped off the line on the return, right?
correct,
There's also no indication that he raised his arms for balance, right?
correct.
There's also no indication that he turned incorrectly, right?
On the return, but turning incorrectly on the return really makes no sense because there's no return on a turn. The turn is a transition portion.
Right. No. And I'm not arguing with the officer. Again, I'm just going off your report.
Right. Okay.
Okay. And then also you didn't mark on the return that he took the incorrect number of steps returning, correct?
Correct.
Okay. Now let's move on to the one leg stand.
Yes, sir.
Okay. And on that one, pretty simple. You asked him to lift his leg. He followed your instructions and chose to lift up his right leg, right?
Yes, sir.
Okay. Then he also followed your instructions and kept his arms by his side, right?
Yes, sir.
He also followed your instructions and did not look down at his foot while performing the test, right?
Correct.
Okay. And then you ask him again whether he had anything to drink, and he said no, right?
Correct.
Okay. Then after this test, Officer Tustison, and we talked about it briefly, I think you said at this point, you had made your arrest decision, right?
Based off the clues, yes, sir.
Okay. And if I remember correctly from direct examination, I think when the state asked you, you said, I made my arrest decision at this point based from the alleged driving violations, the interview with Mr. Tapia, and then the standardized field sobriety test, right?
Yes, sir.
Okay. Now, as you walk him to the front of your patrol vehicle, again, he follows your instructions and doesn't give you any problems, right?
Correct.
Okay. And prior to, or let me rephrase it, Officer Tustison. Do you then at that point get back in your car after the handcuff and ask Detective Henning to tell you whether or not he can smell any alcohol?
I don't remember asking him. I think
Okay.
he volunteered it, I believe.
Okay. Okay. All right. And you didn't find any alcohol containers in Mr. Tapia's truck, correct?
Correct.
Okay. No drugs when you searched them, right?
Correct.
Okay. No weapons either?
No, sir.
Okay. And then when questioning him further, just to reiterate, you didn't follow up on that belief that you had about the dried vomit next to the door, correct?
Correct.
Okay. Thank you, officer. No further questions, Your Honor.
State any redirect.
Yes, Your Honor. Officer, are you familiar with Transportation Code Section 545.058?
Can you hold on a second?
Yes,
Right
sir.
now on my screen, I see only you, Mr. Edelman, and the frozen photo of the arrest.
I see Your Honor, myself, Mr. Tapia Badillo, Ms. Rivera, Ms. Officer Tustison, and Mr. Cabañas.
That's my point. Can you eliminate or remove the frozen video? There you go. Thank you very much.
You're welcome, sir.
Proceed.
Now, officer, are you familiar with that Transportation Code provision?
Based off the number, no, sir. I don't know what that number is.
All right. Perhaps you know it better as driving on an improved shoulder.
Yes, sir.
Could you briefly explain to the court what that Transportation Code provision entails?
I can't say that verbatim, but you're not allowed to drive on an improved shoulder unless you're, I believe there are certain conditions on which you can. I think it has to do with whether or not you have a disabled vehicle or there are certain conditions when you can. But
Well, let me ask you if you perceived any of the following at the points where you perceived Mr. Tapia driving on the improved shoulder. Did you see him stop, stand, or park?
No.
Did you see him accelerate before entering the main traveled lane of traffic?
On the improved shoulder or?
Yes.
No.
Did you see him decelerate before making a right turn?
No, sir.
Did he enter the improved shoulder to pass another vehicle that was slowing or stopping on the main travel portion of the highway that was disabled but preparing to make a left turn?
No, sir.
Was he
Excuse me.
allowing?
Excuse me, I missed part of that. Last thing I heard, Andrew, was then slowing or stopping.
On the main traveled portion of the highway, disabled or preparing to make a left turn.
Thank you.
Did you see him allow another vehicle traveling faster to pass?
No, sir.
Were there any official traffic control devices requiring him to travel on the improved shoulder?
No, sir.
Was he attempting to avoid a collision?
No, sir.
Now, if you remember your NHTSA manual, does it require as an absolute that a person be oriented with their vision away from a highway or roadway?
No. No.
So it's circumstantial. It depends on the context of the situation.
Yes, sir.
Regardless, when you performed the HGN evaluation on Mr. Tapia, did you notice any optokinetic interference?
If you mean if I noticed anything other than him looking at the stimulus, no.
That's correct. Did you notice him following any stimuli other than the stimulus that you control?
No, sir.
Why did you perform the HGN a second time following administration of the HGN, the one leg stand and the walking
It's the same reason why we do 2 passes for each eye, just another confirmation.
So you didn't perform that second HGN evaluation because there had been some interference with the first that invalidated its results?
No, sir.
And your second administration of the HGN, what results did you perceive?
Again, it was just further confirmation. If you notice from that second bout of HGN, it wasn't even, I didn't go, had that been the same as the first one, then I mean, I didn't do any qualifications or anything like that. It was just a confirmation for the HGN from what I saw in that first one.
And did the second administration confirm the results of the first?
Yes, sir.
Now, did you take into account all of the factors that Mr. Cabañas pointed out to you about Mr. Tapia and his demeanor, speech, mental awareness? Did you factor all those into your arrest decision?
Yes, sir.
And in what way did you factor them in?
In the sense that I mean, the way I factored it in was I looked at how he was driving, I looked at the interview, and I looked at the results from the standard field sobriety test. I put all those together and made that determination that he was impaired.
Did you also put together the factors that Mr. Cabañas pointed out and then decide that the factors of intoxication outweighed the factors of intoxication?
Yes, sir. Drunk drivers aren't cookie cutter. Some do well in some portions, others do well in other portions. They don't all come the same. So
now, when Officer Henning gave you the 3 factors, did he order you to consider those, or did he advise you to consider them?
He told me what he usually does to determine whether or not he's going to conduct those SFSTs.
Did he tell you to substitute his judgment for your own?
No.
So you were making your decisions independently?
Making my decision what?
Independently?
Yes, sir.
And what were the 3 factors that Officer Henning communicated to you?
I believe I remember 2 of them, or well, I believe there were 3. One was that whether or not he'll conduct standard field sobriety tests if they're coming from a place that offers alcohol, where they drink alcohol. At the time, I wasn't super familiar with diversions gaming. He said if their driving is bad enough, that he'll conduct standard field sobriety tests. And the other one, I'm not entirely sure. I think it's if they admit to drinking, I think.
Did he tell you that any of those factors was determinative?
No.
Now, when you perform the standard field sobriety test, which of the SFSTs is the most reliable or revealing?
The horizontal gaze nystagmus.
Thank you. Pass the witness.
Anything further, Mr. Cabañas?
Judge, just real quickly, Officer Tustison, you keep talking about the interview, but in the interview with Mr. Tapia, he answered all your questions, right?
Yes, sir.
Okay, so is it just because he answered them in a way that you thought was unusual that you still had that hunch that he was intoxicated?
The interview is more than just the questions and answer portion. It's also what you observe through his speech. Now, we mentioned we didn't notice any slurred speech, but this is just as a general rule. You look at overall factors, whether or not they have glossy bloodshot eyes, they're unsteady on their feet, or anything like that. It's not necessarily just the question and answer. It's also what you observe from that personal contact.
Okay, because the personal contact, according to your report, is only the time that he was in the vehicle, right?
Right.
Okay, and so that's when he answered all the questions, correct?
Yes, he answered those questions. Again,
Okay.
like I know.
Okay. And now, just to clarify, we all know that there's a difference between a highway lane and a shoulder, right?
Yes, sir.
Okay. Now, when the state asked you about driving on an improved shoulder, driving on an improved shoulder means when the vehicle is actually driving on that shoulder part of the highway, right?
Yes, sir.
Okay. In Mr. Tapia's case, his tires just hit the shoulder marker, right?
On some portions, on other portions, his passenger side tires actually went on to the improved shoulder.
That's right. But he stayed on his driving lane, correct?
Yeah, the majority of his vehicle, yes, I'll give to you, was in the main lane.
Okay. All right. Thank you. No further questions, Judge.
Thank you. Anything further, Mr. Edelman?
I apologize. No, Your Honor.
Very good. And the witness, Officer Tustison,
Yes, sir.
at least in my court, let me suggest to you that you, in your testimony, never refer to drunk driving. What was the charge, sir? Is there anything in
driving-
your documents that say drunk driving?
You're correct, sir. I'm sorry about that.
It's one of the things that I have particular umbrage. I've even argued or disagreed with the Mothers Against Drunk Driving. You and I should know, and the prosecution and the defense, we all should know that a person becomes intoxicated way before they're drunk. So just for what that's worth to you.
I appreciate it. Thank you.
All right. May the witness be excused. Mr. Edelman
No further questions for this witness. He may be excused.
and Mr. Cabañas.
Yes, Your Honor. Thank you, Officer Tustison.
All right, officer, you and your loved ones be blessed, be well, and be safe, okay? And you're
Yes.
excused. You are
Thank you.
excused.
Thank you, gentlemen.
All right. Argument, Mr. Edelman.
Well, it is the defense's motion, is it not, Your Honor?
Well, the burden had shifted, but okay, we'll go with the defense. You want to make your argument?
Unless the defense would rather have the state proceed first.
No problem. Let's just go with Mr. Cabañas. Make your final argument, please.
Thank you, Judge. Can I share my screen, please?
Of course.
Your Honor,
Yes.
just to let the court know, there is another officer waiting.
Oh, I thought that was it.
No, sir.
I apologize. Mr. Edelman.
I don't intend to call Officer Henning.
Okay. How do you spell his last name?
Henning, sir.
Oh, Henning. Okay. I wasn't sure it was Henny or Henning. Very good. Thank you. All right. Would you inform the second officer that he is excused, Patricia?
Yes, sir.
Thank you. All right, Mr. Cabañas.
Yes, Your Honor. Give me a second. I'm closing some windows so I could find the one that I'm looking for. Let me close them up.
If you don't, I sure as heck don't.
Give me a second, Judge. Let me close these out. All right, let's see if I can find it now. Okay, there we go. All right, Judge. And Mr. Edelman, can you all see that? Ms. Rivera, can you see that?
Yes.
Yes.
Okay. Judge, so with regards to Mr. Tapia Badillo, we're here on a driving while intoxicated first offense. It's a defendant's motion to suppress. And my argument, Judge, is as follows. Number one is that Mr. Tapia did not commit a traffic offense. Swerving within a lane is not a traffic offense. I'll talk about that a little bit later. Officer Tustison did not have any reasonable suspicion that Mr. Tapia was intoxicated. And finally, Judge, Officer Tustison improperly administered the standardized field sobriety test, thereby rendering whatever results he may have found or claimed to have found invalid. So one of the questions, Judge, that I asked Officer Tustison and I confirmed was what exactly my client was alleged to have done. And Officer Tustison said that his passenger tires hit the shoulder lane or the shoulder line. And then on one occasion, he mentioned, they eventually went over to the shoulder. Okay. What we know from Texas Transportation Code 545.06 is that an operator shall, as nearly as practical within his lane, okay, may not move from that lane unless the movement can be made safely. Now, what did we learn from Officer Tustison? That my client's vehicle stayed within its lane. It did not cause any accidents, did not hit any vehicles, did not hit any barriers. It was driving with the flow of traffic. It was driving the speed limit. It slowed down, and the officer admitted that it slowed down as it exited the highway in order to come to a complete stop. So if we apply the officer's testimony to the transportation court, Your Honor, we find that there is no traffic violation whatsoever. But let's move on to the second point, Judge, and let's assume for a second that the officer believed there may have been a traffic violation, okay? Let's talk about reasonable suspicion. The officer's, Judge, must use the least intrusive means to verify or dispel their suspicion that any criminal activity was going on in a very short period of time, okay? We saw from officer's testimony that Mr. Tapia answered all his questions. Mr. Tapia did not smell of alcohol, nor did he have alcohol on his breath, okay? And even Officer Tustison admits that Mr. Tapia did not have any problems while speaking. If you look at the chart next to this, Your Honor, you'll see that under reasonable suspicion, which again is a standard for Officer Tustison to determine whether or not any criminal activity was going on, in this case, any driving while intoxicated, we see the factors that I asked him. Did he stop the car safely? Yes, he did. Reasonable suspicion? No. So all those factors that are listed there, Judge, turning off the car, placing it in park, rolling down the windows, giving him his driver's license, telling him where he was coming from, letting him know numerous times that he did not have any alcoholic drinks, telling him where he lived correctly, how long he's owned the truck. He's from San Antonio, that his house was literally right down the street from where he was driving or stopped. He recited his ABCs correctly. He gave the officer his address, which was verified and confirmed from his driver's license. He told the officer he was close to his house. He spoke softly and he articulated his words. And those, Your Honor, that is neither any indication whatsoever of reasonable suspicion, okay? Now, what happens after the officer dispels his suspicions through the investigation? Remember, the least intrusive means. According to Illinois versus Wardlow, Judge, the officer has to allow the individual to leave if the officer does not learn of any facts rising to the level of probable cause during this temporary investigation. Okay. However, I still have a hunch. I still believe he may be intoxicated. Again, Judge, according to Wade versus State, a court of criminal appeals case, a mere hunch or suspicion is not enough. And I'm going to focus, Your Honor, the argument today, not the argument, I'm sorry, but this particular case of Davis versus State by the Court of Criminal Appeals, which is a great example. In that case, the Court of Criminal Appeals ruled that somebody being tired, not intoxicated, and no odor whatsoever of alcohol or drugs was sufficient to dispel the officer's suspicion in that particular case. The court also held that the officer investigation was complete, again, after hearing about the driver being tired, not intoxicated, and any lack of odor whatsoever, that once that was complete, the court ruled that the officer in that particular case should have let the driver go because he was not intoxicated. In this case, Judge, we have exactly that. We have the officer still, and he testified, he had a hunch, he had a suspicion, okay? The interview, which is very important, the interview in which my client answered all of his questions correctly, dispelled his suspicion. He said, I'm coming from a game room. I did not have anything to drink. I'm going home. I've never been pulled over or have any traffic tickets. This is my truck. Uh, he opened the door. He didn't have any trouble. All those issues or all those answers, Judge, are more than enough, according to case law, are more than enough to have dispelled the officer's suspicion that my client was intoxicated. And what should the officer have done? Allowed Mr. Tapia to continue on his way home. So I still have a hunch. For whatever reason, the officers still believe, whether it was because he was just learning or whether it be because he was fairly new to the force, but he still had a hunch. We know he didn't have reasonable suspicion. Now we know that he did not have probable cause. Okay. Case law, again, Judge, any further detention at that point has to be based on probable cause. The facts have to give rise to a level of probable cause. Otherwise, the officer cannot extend his investigation. All right. So on facts similar to this case, we know from officer's testimony that if he did not have facts leading to reasonable suspicion of intoxication, then he by no means had any facts leading to probable cause, okay, to continue his detention. He did so improperly, okay? We have, the officer talks about the standardized field sobriety test. Again, Judge, from his testimony, we know he did it without any reasonable suspicion, without any probable cause, just a hunch. The state strategically skipped over the fact that my client performed the alphabet test without any problem whatsoever. We know that the officer did the HGN test incorrectly, okay? Case law, State versus Evans, tells us that a driver should not face the lights or police cars, otherwise the HGN test is invalid, okay? We have the walk-in turn in which the officer tried to correct his testimony and tried to make it worse so they could sway the court into believing he was doing the right thing. But we only have two clues, and you could see it from his own report. Only two clues on the return and no clues whatsoever on the return, excuse me. And again, the officer tried to minimize the importance and saying, well, it's not really relevant. It doesn't really apply. There's a reason why that column is there. And that reason, Judge, is because the officers have to note if there's any signs of intoxication or any clues. And in this particular case, he only noticed two clues out of a possible 16, 8 going forward and 8 going back. On the HGN, we saw that there are not, well, because it was improperly administered, that test is invalid. We heard the officer testify, and it's on the video, that the first time he did it, he had Mr. Tapia facing oncoming traffic behind him, which the cars distracted Mr. Tapia. We also heard from the officer testify that both his patrol vehicle and Detective Henning's patrol vehicle's lights were blinding or were right on the face of Mr. Tapia. Okay. And it's also important, Judge, because the officer during direct examination tried to dissuade the court or sway the court into believing that Mr. Tapia did extremely poor and extremely horrible on the standard field sobriety test by adding testimony that if you look at this report, from Officer Tustison, there are absolutely no observations on the bottom part of that document. If in fact Officer Tustison had seen these things in that particular moment, he would have put them right there on the report, but they're not. Magically or strategically, he only came up with them today, again, to let the court know or sway the court into believing that Mr. Tapia was intoxicated. So in summary, Judge, we are asking the court to suppress my client's stop, the arrest, and any statements. Mr. Tapia, we know, did not commit a traffic offense. Even if we assume that he did commit a traffic offense, or even if we assume that the officer reasonably believed he committed a traffic offense, officer testified that he still had a hunch. We know from his testimony that he did not have any reasonable suspicion to believe Mr. Tapia was intoxicated. We know that he did not have any probable cause to extend the period of detention. Okay, we know that he improperly administered the HGN test. We have 0 clues on the one leg stand, and then 2 clues, 2 subjective clues that he somehow sees when he performs the first part of the walk and turn, but not on the return part of the walk and turn. And lastly, Judge, I want to highlight that part, the video. And I asked the court to take judicial notice of the video and to see it if the court thinks it should see it, because the video is loud and clear, and it lets the court know that Mr. Tapia had no signs of intoxication. Officer Tustison, because of lack of proper training or because he was new to the force, made a bad mistake, a very bad lapse of judgment that brings us today, Judge, for us to be asking the court to suppress the stop, the arrest, and detention of Mr. Tapia. Thank you, Judge.
You're welcome. Mr. Edelman.
Well, Your Honor, unfortunately, the defense counsel has given the game away because he wants you to believe, for example, that Mr. Tapia was driving the speed limit. And he was, until he wasn't. So if the court will notice, this is Mr. Tapia's vehicle. The court can see almost the entirety of his passenger side wheels crossed over the fog line and onto the improved shoulder. That is a violation of 545.058, not only because of his position of the tires on the road, but also because of the 7 justifications for being in that position that Officer Tustison did not perceive at the time. Additionally, Officer Tustison perceived Mr. Tapia traveling at, if I remember correctly, 65 miles an hour in a 45-mile-an-hour zone, eventually slowing down to 40 to 55 miles an hour, which the court may notice is still 10 miles over the posted speed limit for that area. So the officer had 2 justifications for detaining Mr. Tapia. He had the violation of 545.058 and violation of 545.352. And this is what I mean by the defense giving the game away. The court wants you to believe that you're not seeing what you're actually seeing, or that Officer Tustison is not perceiving what he's actually perceiving. For instance, the defense counsel has argued that Officer Tustison perceived no signs or indications of intoxication, and that's simply not correct. Officer Tustison did not perceive every single possible indication or sign of intoxication, but he perceived the operation of Mr. Tapia's vehicle on the roadway. He perceived glassy and bloodshot eyes when making personal contact with him. He perceived what he characterized as a greater effort than normal to articulate his words. He perceived what he believed to be dried vomit not only on the vehicle, but also on Mr. Tapia. Now, does that lead to reasonable suspicion? Well, I think it's important that Mr. Cabañas has not actually laid out the definition of reasonable suspicion, because it is not whether conduct is more consistent with innocent than criminal activity. It is whether there are specific and articulable facts that lead a person of reasonable prudence to believe that a crime is being committed, has been committed, or will be committed. Officer Tustison gave the court those specific and articulable facts that gave him reasonable suspicion to believe that Mr. Tapia might have been intoxicated. And so he did proceed into the least intrusive means of investigating his reasonable suspicion, the administration of the HGN, the one-leg stand, and the walk and turn. Now, as I asked Officer Tustison to point out in his testimony, the standard field sobriety tests are not absolute. They call for approximations because in the field, the situation needs to be fluid and needs to take account of the context that presents itself to the officer and to the defendant. So, did Officer Tustison perceive any interference by the lights of his rear vehicle to Mr. Tapia's performance on the HGN? No. Did he perceive any interference by the movement of the vehicles in Mr. Tapia's line of vision to his administration of the HGN? No. And even if he had, when Officer Tustison re-administered the HGN, he found the exact same clues with none of the potential interference. That's 6 out of 6 clues on what Officer Tustison testified was the best, the most reliable, the most revelatory of the standard field sobriety tests. Defense counsel has given the game away. It wants you to look at the case and not see the things that are right in front of you. Defense counsel wants you to look at the case and not see reasonable suspicion when it's very plain. Perhaps not enough to get you to beyond a reasonable doubt, but that's not the standard that we're applying here. When the court takes into account the totality of the circumstances, Officer Tustison had the legal authority to detain Mr. Tapia, and he had probable cause to place him under arrest. And so for those reasons, the motion should be denied.
I have some questions for both of you. Why did I not hear any actual discussion between the officer and the defendant? Where's the evidence on that?
That would be contained in a separate body-worn camera video. I chose the specific video that I did for the purpose that it provided what I believed was the best overall view of the interaction between Mr. Tapia and Officer Tustison. But I can submit the body-worn camera footage to the court that has better audio if the court would like it.
Well, at this point, you have rested your portion of the evidence. To hear anything further or see anything further would require that the defense agree to that. I had simply a question of, I didn't hear anything. I don't know if the instructions that the officer gave were true and accurate. I suspect he's trained to give them, but I don't know. I don't know how you can count against a person that they take the time to be careful and articulate. I found that very unique, but I didn't hear it, so I don't know. Anything else from either side?
Your Honor, if I may, and with regards to in this case, the defense not showing the court the video, the body cam video by Officer Tustison, and my client, Judge, again, I'm having some issues uploading videos. The video that we got was back in 2018, so I have it in a DVD, and so I'm having difficulty uploading it to my computer, subsequently transferring it to a drop share.
Well, you know, whether you were happy with your choice or not, that was your choice. My question was there a lack of existence of voice? Simply, I'm told, and obviously, that there is voice to the recorded material. Okay,
There is, and I don't.
that was a choice that state made, and apparently a choice that you made. Whether I agree with your choice or not has nothing to do with it. All right. Anything else?
Judge, just to address your last reference or request, the defense counsel does not have any opposition or objection to the state submitting the body cam video with audio for the court to see if it feels like it needs to see that interview, which again is very telling of our point, Judge, but we have no objection if the state wants to do that as well.
And Your Honor, may I speak?
Of course.
I believe it's Code of Criminal Procedure 28.016 that gives the court its authority to decide in what way evidence will be presented in motions to suppress evidence when those hearings are allowed.
No problem.
My mistake, sir. I believe it's...
Regardless, there was reasonable suspicion. Whether I have 100% certainty in my mind, it is clear on the video that the officer observed Mr. Tapia, and by the way, that's the way you pronounce it, Mr. Hillman, Tapia.
Tapia.
Mm-hmm. Now, the second part of his testimony that established in my mind reasonable suspicion for the stop was that he testified that prior to stopping Mr. Tapia, he had reduced the speed but was still doing 55 in a 45. That is reasonable suspicion. Now, I'm going to grant the motion to suppress, and I will tell you that I base it quite simply on the fact that once he determined in my mind, or should have determined as a reasonable police officer, that he got him to recite the alphabet, he talked to him. The thing that I don't understand and calls in question his testimony to me was that the man articulated too well. And that's, to me, that's almost going out of your way to find something that's not there. In my opinion, then he should have released him at that point. He does not articulate a good reason for him to administer the SFSTs. So that's my ruling, and we're through.
Thank you, Judge.
All right, Patricia, what do we have in the morning? Well, we'll have hearings in the morning, right?
Correct.
Want me to go off the record?